Salient features of the Indian Constitution. Introduction. A constitution is a set of principles that explains the political system of the state, the powers and functions of the government, the rights and duties of the people, and the relationship between the rulers and the ruled. The Constitution gives expression to the national consciousness, aspirations and ideals of the people. The Indian Constitution is both evolved and deliberate. The freedom movement, the social reform movement and the awakening of the people during British rule on one hand constitutes the evolutionary part, and on the other hand the formation of the Constituent Assembly, its representatives who debated and discussed and framed the Constitution after independence, constitutes the deliberate part. The Constituent Assembly, headed by Dr. Rajendra Prasad as the President and Dr. B.R. Ambedkar as the Chairman of the Drafting Committee, framed and adopted the Constitution in a span of 2 years, 11 months and 18 days. This was possible because of the distinguished leaders and statesmen who worked with zeal in framing the Constitution. Salient features. First one, Lengthiest Constitution. The Indian Constitution is a lengthy and elaborate document. In its original form, it contained 395 articles and 8 schedules. The Indian Constitution is the bulkiest constitution. Why? Due to the vastness of the country, its diversity and the peculiar problems it faced. The length of the Constitution is due to the following factors. First, the Indian Constitution provides a constitution not only for the Union but also for the states. Second, the Indian Constitution has reproduced the Government of India Act 1935 because people were familiar with the provisions of this act. Third, there is an entire chapter on fundamental rights in part 3, Directive Principles of State Policy in part 4, and fundamental duties in part 4a. This was done to safeguard the rights and interests of all communities, especially the minorities. Fourth, the Constitution has provisions relating to the relations between the centre and the states, as well as between the states themselves. Why? To eliminate conflicts. Fifth, the Constitution has provisions about the organization of the judiciary, the Public Service Commission, the Election Commission, so as to not jeopardize the smooth working of democracy. Sixth, the Constitution has a section which deals with the scheduled caste and tribes and backward classes and Anglo-Indians in part 16. Seventh, the Constitution has a section on official language in part 17, and in part 18 emergency provisions are embodied. Eighth, the Constitution has special provisions to meet regional problems and demands in certain states like Nagaland, Assam, Manipur Sikkim, Mizoram, Andhra Pradesh, Gujarat and Karnataka, Maharashtra, etc. in Articles 371 to 371J. Ninth, the Constitution cannot be static. It has to change with the changing times. So, Part 20 provides procedure for the amendment of the Constitution. Second point, influenced by other constitutions. The framers of the Constitution adopted the best features of some prominent constitutions, modified them to eliminate the faults, and adopted them to suit our country. First point, a large party comes from Government of India Act 1935, like the federal system, Office of Governor, Judiciary, Emergency Provisions, Public Service Commissions and Administrative Details. Second point, the Parliamentary Government, Post of Prime Minister, relations between the Executive and Legislature, Single Citizenship, Cabinet System, Lok Sabha, more powerful, bicameral legislature, rule of law, Speaker of Lok Sabha, comes from the British Constitution. Third, the Directive Principles of State Policy, method of electing the President and nomination of members to the Rajya Sabha by the President comes from the Ireland Constitution. Fourth, written Constitution, impeachment of the President, Supreme Court, fundamental rights, judicial review, independence of judiciary, preamble of the Constitution is adopted from the American Constitution. Fifth, procedure for amendment of the Constitution and election of members of the Rajya Sabha from South African Constitution. Sixth, federation with a strong center, appointment of state governors by the center, residuary powers in the center, advisory jurisdiction of the Supreme Court from Canada. Seventh, the ideals of republic, liberty, equality and fraternity in the preamble from the French Constitution. Eighth, the concurrent list, joint sitting of the two houses of parliament from Australia. Ninth, fundamental duties, ideal of justice and 5-year plans from former USSR. 10th, suspension of fundamental rights during emergency from Germany. 11th, concept of procedure established by law from Japan. There was criticism due to dependence on Western constitutions, but the critics had no blueprint of their constitution. Moreover, people of India were familiar with Western concepts and institutions. As a result, the Western model was ideal and therefore adopted. Third, balance between rigidity and flexibility. Article 368 of the Indian Constitution lays down the procedure for amending the Constitution. They are as follows. First, some provisions can be amended by a simple majority as it is required for ordinary legislation. Second, some provisions can be amended by a majority of the total membership of the House and by a majority of not less than 2/3 of the members of that house present and voting. Third, some provisions can be amended by a special majority of the Parliament and ratified by legislature, that is Vidhan Sabha, of not less than one half of the states. Thus, the Constitution has a combination of rigidity and flexibility. Please note, only point 2 and 3 are mentioned in Article 368. Fourth point, federation with a unitary bias. India is a federal state because it has federal features like: first point, there are two sets of government, that is, central government and state governments. Second, there is constitutional division of powers between the center and the states. Third, the Constitution is supreme. Fourth, there is an independent judiciary. Apart from federal features, India also has unitary features. First point, Article 1 of the Indian Constitution describes India as a union of states and not as federation of states. As a result, no states can secede from the Indian Union. Second, there is an integrated judiciary. Third, the system of single citizenship exists. Fourth, there is a single constitution for the center as well as for the states. Fifth, the state governors are appointed by the president. Sixth, during an emergency, India is converted into a unitary state. Thus, the federal system was adopted to preserve the diversity of India, and the unitary system was adopted to enable India to undertake planned development which would help in the establishment of a strong and prosperous India. Thus, India has been regarded as a quasi-federal state. Fifth, parliamentary sovereignty and judicial review. The notion of parliamentary sovereignty is connected with the British Parliament, and judicial review is associated with the American Supreme Court. Judiciary has the power to declare legislative and executive enactments as unconstitutional if it goes against the basic framework of the Constitution through its power of judicial review. Parliament, on the other hand, can amend the Constitution through its constituent power. The power of the judiciary is curtailed because our Constitution uses the term procedure established by law and not, as in the American Constitution, due process of law. Moreover, the Constitution can be amended by Parliament by a special majority if the judiciary is overbearing. This has been clearly pointed out by Pandit Nehru. Judiciary can pull up the sovereign will if it goes wrong, but in the ultimate analysis, where the future of the community is concerned, no judiciary can come in the way. Sixth, parliamentary government and an elected head of state. Our founding fathers adopted a parliamentary form of government, both at the center and in the states along the British lines rather than the presidential system of United States. The features of parliamentary government in India are presence of nominal and real executive, fusion of powers, majority party rule, Prime Minister and Council of Ministers, members of legislature, collective responsibility, importance of Prime Minister, and a responsible and responsive government. India declared herself as a republic, and therefore it was decided to have a nominal executive, that is, president, who will be elected indirectly by the people, which is based on Irish constitution. The president is bound to act on the aid and advice of his council of ministers. Seventh point, integrated and independent judiciary. Constitution has established an independent and integrated judiciary to settle disputes and pronounce judgments without fear or favor. Judiciary free from legislative and executive control. The mode of appointment and removal, security of tenure, ban on practice after retirement, punishment for contempt of court are factors adopted which keep the judiciary independent. The Supreme Court at the top of the integrated judiciary. Below it are the high courts at the state level. Below the high courts, there are subordinate courts. All the courts enforce both central and state laws. 8. Secular state. The Constitution stands for a secular state. The Constitution does not uphold any particular religion as the official religion. The Constitution states that all have the right to freely profess, practice, and propagate any religion. Every religious denomination has the right to manage its religious affairs. Any educational institutions maintained by the state cannot provide religious instruction. The minorities have the right to establish and administer educational institutions of their choice. Thus, India gives equal respect and protection to all religions. 9th, universal adult franchise. Despite poverty and illiteracy among the vast sections of the Indian people, our authors adopted the principle of universal adult franchise because of their faith in the common man to make democracy successful. The universal adult franchise is based on the principle one man, one vote. The voting rights are given to all citizens above the age of 21 years without discrimination. There was a change which took place with the help of the 61st Constitutional Amendment Act 1988, where the voting age was reduced to 18 years. There were apprehensions about the success of universal adult franchise, but the doubts were cast aside after the success of the first general election held in 1952. 10th, single citizenship. India is a federal state, but unlike United States, where a citizen is not only a citizen of USA but also a citizen of a particular state to which he or she belongs. India, on the other hand, has provided for single citizenship, that is, the citizen of India only. 11th, emergency provisions. To meet any extraordinary situation, the Indian Constitution gave the President the power to declare emergency. This safeguards the sovereignty and integrity of the political system. There are three types of emergencies: national, state, and financial emergency. During emergency, all the powers are vested with the central government. Citizens' rights are curtailed and the federal structure is converted into a unitary one without a formal amendment of the Constitution. 12th, fundamental rights. 6 fundamental rights are embodied in Part 3 of the Constitution. These rights are essential for a democracy, not only for the enjoyment of social, civic, and religious life, but also for meaningful political participation. They are justiciable in nature. Individuals can approach the court if their rights are violated, and the courts can issue writs for the restoration of rights. Fundamental rights are not absolute. They are subject to reasonable restrictions on the basis of sovereignty, security, public health, morality, etc. Fundamental rights can be curtailed or repealed by Parliament through constitutional amendment. For example, right to property, or during emergency, rights can be suspended. 13th, Directive Principles of State Policy. The Directive Principles of State Policy are embodied in Part 4 of the Constitution. The aim of the Directive Principle of State Policy is to achieve social and economic democracy. Directive Principle of State Policy was embodied for establishing a welfare state. The Directive Principles of State Policy are non-justiciable, that is, they are not enforceable by the courts. There are fundamental principles of governance of the country. The makers of the Constitution regarded Directive Principles of State Policy as guiding principles for the state to make laws. 14th, fundamental duties. It is embodied in Part 4A, Article 51A by the 42nd Constitutional Amendment Act 1976 on the recommendation of the Swaran Singh Committee. There were 10 fundamental duties. The 11th one was added by the 86th Constitutional Amendment Act 2002. The fundamental duties are to abide by the Constitution, respect the national flag and national anthem, to respect and protect sovereignty, integrity and unity of the country, to defend and serve the country, to promote harmony and the spirit of brotherhood amongst all the people, to preserve the rich heritage of our composite culture, to protect natural environment, to develop scientific spirit of inquiry, to protect public property and prevent violence. Parent or guardian must provide opportunity for education to their children up to 14 years. Fundamental duties are non-justiciable in nature. They inculcate social values and awareness about our responsibilities as a citizen. That is, while enjoying rights, one has to be conscious of one's duties.